In this subunit, we're going to discuss the UCC approach to the excuse doctrines. So we've been talking about excuses, and these are our excuses. Remember, we're looking at excuses as performance defenses. I should be discharged from my performance under this contract for some reason. The reasons are mutual mistake, unilateral mistake, impossibility, impracticability, and frustration of purpose. We've been through the common law doctrines. Now let's talk about how the UCC approaches excuses. There are two relevant provisions under the UCC. UCC 2-613, casualty to identified goods, and 2-615, excuse by failure of presupposed condition. Let's go and look at these in some greater detail. All right, let's look at section 2-613 and see how it addresses one or more of the excuses that we've already talked about. Now, before I go through the statute, what I'd like you to do is I'd like you to pause here, and I'd like you to look at the statutory provision, section 2-613, and I'd like you to parse through the statute and pick out the important elements of the statutory provision, right? This is a skill that you know that you need to develop. So pause right here. All right, I'm going to assume that you paused and you went through the statutory provision and that you came out with these elements. So 2-613 applies to casualty to identified goods, right? So what are the important elements? Well, the goods have to suffer some sort of casualty. They have to be damaged in some way without the fault of either party. And it's a type of contract that requires the goods to be identified when the contract is made. What does that mean? Well, simply it means that it is a contract for this specific good and not any good. So for example, imagine we enter into a contract for the sale of a bowling ball, right? That does not require the identification of a specific good when we enter into the contract. It is a bowling ball. Right? If we, however, enter into a contract for the Mona Lisa, that is the type of contract that requires the good to be identified when we enter into the contract. So, for example, imagine we enter into a contract for the sale and purchase of a bowling ball, right? And as we enter into the contract, we say, oh, it's that bowling ball. And I say, okay. And then you take the bowling ball off the shelf, and as you're doing it, you drop it, and it is destroyed. Right? Is this provision, 2-613? And it's not, because this contract did not require us to identify the bowling ball at the time we entered into the contract. Even though we did identify it at the time we entered into the contract, that bowling ball is like any other bowling ball on the shelf. As far as I know, you might know something about bowling balls that I don't know, right? But contract for the sale of Mona Lisa, this is a contract that requires us to identify the good when we enter into the contract, and this is the fact pattern that 2-613 is discussing. All right, let's look at UCC section 2-615. Once again, I want you to pause here just for a second and try and parse out the important elements of 2-615. Pause here, do it. All right, are you back? Did you do it? I don't believe you do it. Okay, now I believe you. All right, so if you went through 2-615, you saw that it just looks almost exactly like our common law doctrine of impracticability, right? There's some sort of delay by the seller, and it's the seller's performance is made impractical by the occurrence of a contingency, the non-occurrence of which was a basic assumption under the contract, right? So it's pretty much the same thing we've already discussed, so we're not going to focus on these elements in detail, but the comments to UCC 2-615 are very instructive. So I'd like to spend some time going through some of the important comments in 2-615, and I think as we go through these, we'll get a better idea of how to apply 2-615 and the doctrine of impracticability in specific situations. So let's do that now. The comments to UCC section 2-615 will help you understand how to apply 2-615, especially in the case where the goods become unavailable for one reason or another. I expect that you will read and want to read through the comments of 2-615 on your own, so we'll just go through some of the highlights quickly. First, let's look at comment 4. Comment 4 talks about when there is increased cost of the goods or a rise or a collapse in the market. So imagine I promised to sell goods to you, but my cost of acquiring the goods has increased for whatever reason, or it has increased because there is a rise or collapse in the market. So the question is, now, do I have a defense of impracticability? I can't get you these goods because it is now impracticable for me to get you these goods because the price has increased for me or because there has been a rise or collapse in the market. What does the comment say? Well, it says these are types of business risks which these contracts are intended to cover. So I, as the seller or supplier, should bear these risks. But the comment goes on. Severe shortage of raw materials or supplies because of war, embargo, local crop failure, unforeseen shutdown of major source of supply. These are the types of events that may give me a good argument of impracticability. So merely an increased cost or merely a rise or collapse in the market, that alone will not give me an argument of impracticability or a good argument of impracticability. It will not excuse my performance to deliver these goods to you under our contract. But if it is caused by war, embargo, local crop failure, unforeseen shutdown of major sources of supply, etc., then my argument that I am excused because of impracticability is much stronger. All right, let's move on to comment number 5. What happens if we agree to a particular source of supply or that the source of supply is not expressly agreed to, but we contemplate it or assume it? So I'm the seller, and now this source of supply fails. Will I be excused? Well, generally the idea is that yes, I should be excused if I have employed all due measures to assure myself that the source will not fail. So now you have to go through it. Imagine you're a seller and you're in a contract with a buyer, and the contract stipulates an exclusive supply source. Or maybe it's not stipulated in the written contract, but the parties contemplate or assume there will be a exclusive supply source. And then for some reason, that source of supply fails. I, as the seller, will be excused, but only if I have used due measures to assure myself that this source will not fail. This could be anything from entering into a contract with the source of supply or going to the source of supply, inspecting their premises, asking about their business situation to get a better idea of whether this source of supply will fail or not. All right, continuing on with comment 5. When we have an agreed source of supply and that source of supply is a manufacturer and the failure of production by this agreed source. I, as the seller, should, if possible, be excused. But here's an interesting thing. The idea is that this source of supply, right, this agreed source of supply has now defaulted on my contract, right? I, as the seller, can't deliver to you, the buyer, but I also should have a contract with my supplier. And if that supplier has breached the contract with me, causing me to fail to deliver to you, if I'm excused from my obligations to you, I should turn over my right to sue my supplier to you. I should assign that right to you. All right, let's look at comment 9. Comment 9 is a very interesting situation. We have a farmer who is contracted to sell crops grown on designated land, right? And for some reason, these crops fail. Should the farmer be excused? And the answer is yes, when there is a failure of the specific crop. This is different from a farmer who says, I will sell you corn, and then fails to deliver the corn. It has to be corn that's grown on designated land and that specific crop fails. When that occurs, the farmer will be excused. All right, so reading through 2-615, there doesn't seem to be any mention of mistake or frustration of purpose. 2-615 seems to be talking about impracticability, and in fact it does use the word impracticable in its provision. So the question is, what about the doctrines of mistake, mutual mistake, unilateral mistake, and frustration of purpose under the UCC? Well, if the UCC is silent on a matter, what do? Do you remember? Section 1-103 says if the UCC is silent on a particular matter, then we flip out to the common law. So in this case, with respect to mutual mistake, unilateral mistake, and frustration of purpose, the UCC is silent. Does that mean that there are no excuses of mutual mistake, unilateral mistake, and frustration of purpose for a contract for the sale of goods? No, it doesn't mean that. It means we flip out to the common law. You will apply the common law doctrines of mutual mistake, unilateral mistake, and frustration of purpose.